Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 118. I've got three cases, of course, no surprises there. And the first looks at territorial jurisdiction for tribunal claims, and it's a really useful illustration of why you need to think about your choice of law clause in a contract. Secondly, we've got a case about disability discrimination and whether a particular set of facts qualifies as discrimination arising from disability. And the third case, well, is one that's been gaining quite a bit of traction, and it's about shared parental pay as opposed to maternity pay and whether there's a potential discrimination trap in there for employers. And finally, I've got a favour to ask. I'll come on to that. As always, don't forget you can access us via iTunes. It's on the Mayor Brown website, it's YouTube, and Twitter, of course, and the Twitter feed Nicholas Robertson at Nicholas Robert ROBER11, and that's where we put out the links for all the cases we've talked about. First up then, Green and SIG Trading Limited. This is an EAT decision on a territorial jurisdiction. It's a really good example of why you need to think about contracts of employment which you're using for employees working abroad and why using standard forms can be dangerous. The position was this. The employer is a UK registered company. It's a subsidiary of UK PLC. The claimant was their managing director for the business in the Kingdom of Saudi Arabia. Claimant, well, he's married to a Lebanese national. He's lived with this family in the Middle East for over 15 years. He took up his post in May 2014. And when he took up his post, continued to live in Lebanon, and he would go over and work in the Kingdom of Saudi Arabia for 2 to 4 days at a time. The respondent paid for his accommodation. He did register for tax in the UK, but was treated as exempt for UK tax and national insurance. Although there was a suggestion in his contract that he was on secondment to the Kingdom of Saudi Arabia, this was accepted to be an error. However, the claimant's contract expressly stated that it was governed by English law, referred to English employment legislation and UK policies on things such as anti-bribery and corruption, and contained a mobility clause which permitted him to be relocated within the UK and Ireland. In other words, he was given a standard UK employment contract, and it seems that they didn't have any operations outside the UK, and that was the contract that came to hand. It was also accepted by the tribunal that it was an important part of the job that the claimant was actually based in the Kingdom of Saudi Arabia, because previous attempts to develop business there with an employee working remotely had not been successful. The tribunal also found that the budget for the operation in Saudi Arabia within the company was an independent item within the UK company's budget and was administered separately from the UK budget. Claimants made redundant. Since the only management in the company is based in the UK management and the HR director in the UK handled the redundancy. The claimant brought claims in the UK employment tribunals and was of course met with the argument that the tribunal could not hear the claim. It was said the tribunal's territorial jurisdiction did not extend to covering this sort of employment arrangement. Well, the employment tribunal agreed with this and said that the comparative exercise between the factors in favour or against jurisdiction showed that the factors, showing the connection with Great Britain and British employment law was in the minority. The Employment Tribunal found that the contract being governed by English law was for convenience only because the employer had reached for a standard form. The claimant appealed to the AT. The law underlying this, let's talk about that for a second. The law underlying this case, of course, is there is nothing express in the Employment Rights Act about territorial jurisdiction. By virtue of a succession of cases such as Ravett and Duncombe, we now know it's clear that employees who are working or based abroad have to show a sufficiently strong link both to Great Britain and to British employment law in comparison with any other system of law. The early cases dealing with this seem to have taken quite a strong line and seem to take the view that this would apply only exceptionally and there needed to be much stronger connections with Great Britain and British law where an individual was based or working abroad. I think this has been watered down a little bit, so it's now the test is a sufficiently strong connection. But there does still need to be a strong connection either way. And the question here, in this case, was whether the claimant could show there was a sufficiently strong connection to Great Britain and British employment law. The EAT accepted that the appeal had some merit to it. In particular, the EAT accepted it wasn't open to the tribunal to dismiss the existence of a clause in the contract saying British law was to apply by referring to the employer's subjective intentions when it put that clause into the contract. It was a fact that the parties had intended to apply British law to the contract. This couldn't be disputed. As such, that was a significant factor pointing towards the Employment Tribunal having jurisdiction. Therefore, the EAT indicated it was minded to send the matter back to the Employment Tribunal to reconsider the comparative exercise, taking account of the existence of this jurisdiction clause as weighing in favour of finding that the Employment Tribunal in England had jurisdiction. Well, I think the learning point from this is all pretty stark. Here we have an individual who was employed by a UK company, but living and working outside the UK. It was essential for his job. He was based in the Kingdom of Saudi Arabia. He'd been living outside the UK when he was recruited. Set against this, however, there's a standard form contract expressly applying British, I assume English, law to the contract, and an English management team to me reported who dismissed him. But the tribunal found, and was found by the EAT to be entitled to find, that this point was simply pragmatic, on the basis that there was no one else around who could handle the redundancy. So the reality is, it seems to me, that the two significant links to the UK were, one, there was a UK employer, and two, there was a contract which was stated to be governed by English law. The EAT sends the case back to the Employment Tribunal because these two factors, it must mean, could be sufficient to give the English Tribunal jurisdiction. Well, I think that's pretty far from having to show an exceptional link to the UK. But there we go. I think the message I take from this is if you're employing someone with a UK company but based and working outside the UK, you need to think very carefully about whether it's wise to have them on an English employment contract. It's not possible to put them onto an English contract but expressly say in that I'm going to disapply English statutory protections. And I've seen that attempted several times. The EAT here make the point that the statutory English protections will apply, irrespective of what the parties say in the contract of employment. If there is an especially strong link, then the statutory protections apply. That must be right. I think it's going to be necessary to consider in each case whether to have local law apply in the contract. If that's not appropriate, then it may be better to ensure that at the time of typically the dismissal, the employer is treating the individual as if he or she were an English employee and applying appropriate procedural safeguards, for example, in the case of making redundancies, so that even if the tribunal has jurisdiction, it doesn't necessarily take the employee anyway because the case can be defended on its facts. So that's the case of Green and SIG Trading Limited. Next up, Charlesworth and Dransfields Engineering Services Limited. And this is an EAT decision on disability discrimination. And the facts in this case were not really in significant dispute. The claimant was a branch manager at one of the 4 branches of Dransfields. The company wasn't achieving sufficient profits, and indeed there had been some discussions at the senior level from time to time, since about 2012, about making cost savings. In summer 2014, the company became aware that the claimant had cancer. In October 2014, he went into hospital for an operation. He came back to work in mid-December 2014, took up his role again. In March 2015, a consultation process started with him, and he was then made redundant. He claimed he'd been discriminated against on the grounds of his disability. It appears to have been accepted that he was disabled, which is unsurprising given what had happened to him. But he claimed that there was no redundancy situation, that he was dismissed because of his disability. This was not accepted by the Employment Tribunal, and the Tribunal found that anyone else without a disability would have been treated in exactly the same way as the claimant. So why did the case go to appeal? Well, the Employment Tribunal decided that the claimant's absence from work for 2 months, quote, was the occasion which allowed the respondent to identify something which it might very well have identified in other ways and in other circumstances, unquote. In other words, the claimant's 2-month absence was part of the factual context that led to his redundancy. The claimant's 2-month absence was, of course, caused by his disability. Therefore, the claimant's appeal went, there is linkage between my disability and my redundancy. It seems that the claimant's absence indeed was from October to December 2014, and by November 2014, the overall head of the company had identified the possibility of restructuring the claimant's job. The question was whether that was enough to bring about and to uphold the claim for disability discrimination. Or was the tribunal right that you could have something that was an occasion that allowed the respondent to identify the ability to make him redundant without that being discriminatory? The underlying legal test in Section 15 of the Equality Act is there is discrimination against a disabled person if, quote, A treats B unfavourably because of something arising in consequence of B's disability, unquote. It is clear that it is not necessary for the claimant's disability to be the only cause of the unfavourable treatment. But the EAT said it was not sufficient to have something that was an influence but not an operative cause. It had to be one of the effective causes of the dismissal. Here, the tribunal had accepted that there was a link between the absence and the illness, as it gave the respondent an opportunity to observe the way in which work would be dealt with if the claimant were not around. The Employment Tribunal had then decided, and according to the EAT was entitled to decide, this was not the same as saying the claimant had been dismissed because of his absence. The tribunal was able to draw a distinction between the context in which the events occurred and those matters that were causative. I think in the context of disability discrimination, this case makes perfect sense from a legal perspective. If something happens and is part of a chain of events but is not a cause, then it should not be held against the respondent. As the EAT points out, disability discrimination in this context, Section 15(1), says that discrimination arises where something occurs because of a consequence of the claimant's disability. The absence did not cause his dismissal in any sense. However, I think it would be dangerous to assume from this that this gives the green light for similar dismissals. I think it probably helped the respondent here that the claimant had come back to work before the redundancy took place. It's also clear that there was a genuine redundancy situation according to the tribunal, so it wasn't a sham. Equally, I have to say, I think I'd have been quite cautious had I been asked about this before, say, they moved ahead to dismiss him. I think the challenge would have been to persuade the tribunal the absence did not, in fact, play any part in the decision-making process. As I say, I think it would have been more difficult an argument to make if the redundancy decision had been taken whilst the individual was away from work rather than after he'd returned. So, that's the case of Charlesworth and Dransfield Engineering Services Limited. Third and final case, or is it? Well, let me explain. Ali and Capita Customer Management Limited. This is an employment tribunal case, and it really ought to come as part of a pair with Hextall and Chief Constable of Leicestershire Police, which is another employment tribunal case. So why am I bringing you two employment tribunal cases, two for the price of one? Well, both are dealing with the issue of whether or not it is possible for a man to bring a direct discrimination claim based on the fact that he receives non-enhanced statutory parental leave pay when a woman on maternity leave for that period would have received enhanced maternity pay. Because, let's face it, it's men that suffer as a result of childbirth, isn't it? Well, before going any further, it's important to appreciate we're talking about enhanced maternity pay and the possibility, if we put it about that way, of enhanced shared parental leave pay. And the background is, it's possible for couples to share parental leave, so it's no longer necessarily the woman who has given birth who is taking time off and receiving maternity pay. A woman who fulfills the necessary conditions by statute can end her statutory maternity leave period early, including her right to receive statutory maternity pay, of course, and share that with her partner. However, can a man who is on shared parental leave and who is receiving pay at the statutory rate complain of direct discrimination if a woman on maternity leave would have been paid at an enhanced rate? In other words, if an employer chooses to enhance maternity pay but only to apply statutory rates of pay for shared parental pay, does this give rise to a potential claim for discrimination? Well, according to the Ali case, yes it does. Mr. Ali wanted to look after his wife, who was unwell following the birth of their child. However, he was told that his shared parental pay would be at the statutory rate, whereas it was accepted that a woman who was on maternity pay with the same employer would have been receiving enhanced maternity pay. He then obviously claims that's direct discrimination, and the Ali case came to the view that Mr. Ali had been discriminated against on the grounds of direct discrimination. They said he'd not been indirectly discriminated against because it was clear that the employer was enhancing maternity pay when it was not enhancing shared parental pay, and that was more appropriately formulated as a direct discrimination claim. The employer attempted to defend the direct discrimination case by arguing that the claimant was precluded from bringing a direct discrimination claim because such a claim is not permitted where the advantageous treatment to the woman, here enhanced maternity pay, was, quote, special treatment afforded to a woman in connection with pregnancy or childbirth, unquote. And that's Section 13 of the Equality Act. Secondly, the employer in the Ali case said that for a direct discrimination claim there has to be no material difference between the circumstances of the claimant and his comparator, and that's obvious. On that basis, they said it was not permissible to compare a man who hadn't given birth, but once paid, with a woman who has given birth and the pay that is given to her. The tribunal in Ali is pretty hostile to all this. They said that in 2016 it was clear that either parent could perform the role of caring for their baby in its first year, depending on the circumstances and the choices made by the parents. Excluding the 2 weeks compulsory leave period, which it was accepted by all the parties in Ali was unique to women who've given birth, after that 2 week period it's possible to make a comparison between a woman on maternity pay and a man on shared parental pay, and the exclusion clause, they said, Section 13 of the Equality Act, did not prevent that comparison being made. The Employment Tribunal then said there was no indirect discrimination claim because this was a matter where the alleged PCP, provision, criterion or practice, maternity versus shared parental pay, was directly gender-based, and so it was really a matter of direct discrimination or nothing. However, the slightly earlier case of Hextall, which I don't think was cited to the Ali case for what it's worth, when confronted with the same issue, in effect, came to the opposite conclusion. It said there was no direct discrimination. It said that a woman who has given birth is in a materially different position from a man who wishes to take shared parental leave. That tribunal thought that the leave periods were also fundamentally different nature. Not least, a woman has a right to maternity leave. A man has only an ability to take shared parental leave with the consent of his partner. Maternity leave can be taken before childbirth, whereas shared parental leave can only happen after childbirth. They also said that a more valid comparator would have been a woman who is the wife of a civil partner of a woman who has just given birth, taking shared parental leave. In both Hextall and Ali, of course, such a woman would have been treated in exactly the same way the claimant was. They also relied on the fact that Section 13, in their view, meant that special provisions for women in connection with childbirth, where the special treatment was reasonably necessary to compensate them from the disadvantages occasioned by childbirth, was outside the scope of the Equality Act. Enhancing maternity pay, therefore, was covered by Section 13, they said, and that was outside the scope, as I say, of direct discrimination. They too, however, did agree with the Ali case, no indirect discrimination. Both cases are being appealed to the AT. Obviously, these cases are ongoing, so any initial tribunal findings and decisions are going to be subject to review. It's obviously, as well, a really important point. My view, for what it's worth, is that this direct comparison is not permitted. Seems to me that if a direct comparison can be made between a woman on shared parental leave and a man on shared parental leave, that's the comparator to which a tribunal should look. To have a cross comparator, a woman on maternity leave, when there is a closer comparator at hand, I just don't think that can be right. Secondly, I do think that Section 13 will continue to preclude a claim for enhanced shared parental pay based on enhanced maternity pay. I also think the tribunals will have to be mindful of the fact that many employers who do not at the moment enhance shared parental pay will downgrade their maternity pay rather than have to extend enhancement across to shared parental leave. Now, obviously, you can argue whether that's morally the right thing to do. Many employers have already levelled up, taking the view that for both shared parental leave and maternity pay they should be enhanced equally, and that's morally and commercially the right thing to do. It's what Mayor Brown have done. So at this stage, I certainly wouldn't be saying to clients it's necessary to change shared parental leave to match any enhanced maternity pay on legal grounds. But I do think the part of the Ali decision which has some resonance is that in 2016 it may be anachronistic to expect all of the child caring responsibilities to fall on the woman. And that in some ways is perhaps the oddity of this. You have two tribunal decisions that disagree on direct discrimination. They both agree there's no indirect discrimination complaint, and yet it seems to me that's possibly a far more fruitful area. If the correct comparator is between a man and a woman on shared parental leave, then surely there's an indirect discrimination argument there, given that those rates are adverse in comparison with other sorts of leave. Maternity leave. I don't know whether Section 13 operates to block that. It'd be interesting to see. But it does seem to me it's more logical to view this as an indirect claim rather than which would then, of course, turn on justification if Section 13 wasn't the answer. Who knows? We will see. I hope, I don't know, I know the cases are being appealed to the AT. I hope they're being appealed on all fronts because I think it'll be interesting to hear the EAT's reasoning. Let's see. Anyway, it'll be interesting to see which way this one goes, and I will, of course, bring you news from the front as and when we have it. So that's the case of Ali and Capita Customer Management Limited, along with the earlier Hextall case and Chief Constable of Leicestershire Police. So, thank you very much for listening. It's much appreciated as always. I did say I had a favour to ask. I've noticed that the listening figures for the podcasts have gone up quite a lot over the last couple of months. It's one of the oddities, as I think I've mentioned before. We've no idea who listens to the podcast, although, of course, every single person who I ever interview for a job in the employment department is, of course, an avid listener to the podcast. But I often wonder whether every now and again, an employment class or employment course somewhere, someone finds the podcast and logs into it, or indeed, who knows, maybe even some tutor is out there advising people to listen to it. Who knows? I'm really quite interested. So listen, if you've started listening to the podcast in the last couple of months, do let me know. I'd be really interested to hear from you. My email address, nrobertson@mayorbrown.com. Do get in touch. I'd be interested to hear. So, I think it only remains for me to say, in time-honoured fashion, that no general elections have been called since I started recording this podcast, at least not as far as I'm aware. And stay safe, everyone, and be back again in a couple of weeks' time. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.